Be seated as you come in. Feel free to have a seat. Thanks. Everybody, thanks, folks. Just have a seat, and everyone else can be seated as well. Thank you. Get settled. Well, welcome to Thurston County District Court. And what we're going to do is pick some folks to stay with us for the next couple of days to hear a case. I'm Judge Wilcox, and I'll be presiding. You've met Mindy over here. And then I'd like to get you introduced to the other folks here. Ms. Pritikin.
Hi, I'm Nicole Pritikin, Thurston County Prosecutor's Office. I'm with the prosecutors.
Ms. Groth, you and your client?
Yes, my name is Danielle Groth. I represent Regis Edmondson.
Thanks. And I've got a few introductory remarks to kind of help you understand what we're doing here. I'm going to stay standing because this is not the best acoustics in here. How are we doing hearing so far? Thumbs up, thumbs up. So anybody, if you can't hear me, you have no idea I'm asking you that. So look around to your neighbors and make sure. But if we do have some amplifying microphones or headphones and microphone, would that help? Anybody need some extra hearing assistance? Pardon?
So far, so good.
So far, so good. Okay. If you do, anybody? Okay, we're going to keep at it. So let me kind of introduce what we're doing here today. This is a criminal case, and this is where we pick, as I said, the people that will stay with us to hear the case. Jury pick, or voir dire in the Latin. So, and this is a criminal case brought by the state, who's represented, as you've met, Ms. Pritikin, by the prosecuting attorney's office. And it's against Mr. Edmondson, and he's represented by Ms. Groth. Those are kind of the parties here that you're going to see. So you've met Mindy, and she's helpful here to me, to you, to the jurors who are finally picked as well. Logistics, not as to legal issues, but to help you make your time here as comfortable as we can. So you'll notice we don't have those people plunking on that strange machine called a stenographer. They're not a stenographer, stenograph. Anyway, we don't have one of those. The Supreme Court says that district courts are to record everything, an audio recording, and that's how we keep our record. And so that's what those red lighted objects are on the table. They don't amplify anything. That's why we offer amplification if you need it. But that's what so we keep the record that way. Let's see. So I wanted to introduce to you what Mr. Edmondson is charged with, so you have a better reference as to what the questions are. What happens in jury pick? I'm going to ask a few questions. I'm going to allow Ms. Pritikin to ask questions. I'm going to allow Ms. Groth to ask questions as well about your qualifications to be a juror. And then after we've all asked our questions, then they're going to join me up here at what we call my bench. Sort of figured all this in the pandemic, so we had some elbow room. And we'll pick those folks that can stay on the jury pursuant to the law. And then that's how it's done. So we'll review that again. So Mr. Edmondson is known as the defendant, and he is charged with, we'll get to that charging document from the state. All right. So Mr. Edmondson is charged with 2 counts, 2 allegations of crimes. Well, count 1 is violation of a protection order. And so you have some reference. The prosecuting attorney has filed this, and you're saying, you okay there? Need some water? Okay, you need some water, we got water. So that the defendant, Regis Eugene Edmondson, here in Thurston County in the state of Washington, on or about February 4th of 2025, with knowledge that he was the subject of a protection order, a restraining order, or no contact order issued by Pierce County District Court, cause number 4A604109A, that on June 3rd of 2024, protecting a Carly Joanne Schluter, and that said order being valid and in effect did knowingly violate a restraint provision or had prohibited contact with that protected party. And the defendant, Mr. Edmondson, did commit the above crime. The allegation is against a Carly Joanne Schluter, an intimate partner as defined under the law. Count number 2 is entitled cyber harassment. And the prosecuting attorney is alleging that the defendant, Mr. Edmondson, was in Thurston County, the state of Washington, on or about February 4th, 2025, with the intent to harass or intimidate Carly Joanne Schluter, did make an electronic communication to that person, and the communication did, 1, use any lewd, lascivious, indecent, or obscene words, images, or language, or did suggest the commission of any lewd or lascivious act, or 2, was made anonymously or repeatedly. And again, the prosecutor alleges that Mr. Edmondson did commit the crime against Carly Joanne Schluter as an intimate partner as defined under the law. So keep in mind that that charge laid by the prosecuting attorney is merely an accusation. That filing of the charge is not proof or evidence that the charge is true. And your decisions as the jurors must be made solely upon the evidence presented during trial. Again, that's a mere accusation. So to the charges, these 2 charges, Mr. Edmondson has entered pleas of not guilty. And the plea of not guilty means that you, the jury, must decide whether the state has proved every element of those crimes charged. The state has the burden of proving every element beyond a reasonable doubt. Mr. Edmondson, the defendant, has no duty, no burden of proving that a reasonable doubt exists. He has no duty to call witnesses, no duty to produce any evidence, no duty to testify. And he is presumed to be innocent. And the presumption of innocence continues throughout the entire trial. And that presumption means that you, the jury, must find the defendant not guilty unless you conclude at the end of the deliberations that the evidence has established his guilt beyond a reasonable doubt. So a reasonable doubt, you're probably going to hear us talk about this phrase often, but a reasonable doubt is one for which a reason exists. It may arise from the evidence or the lack of evidence. A reasonable doubt is a doubt that would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or the lack of evidence. And if after such consideration you have an abiding belief in the truth of the charge, then you're satisfied beyond reasonable doubt. So again, the first stage of any criminal jury trial is jury pick, picking the folks who are going to stay and hear the whole case and make those decisions. And the purpose of this process is to make sure that we select a jury that's free from outside bias or pre-existing bias that might interfere with that juror's ability to fairly decide the case based on the evidence, based on the law that I will give you here in this courtroom. So it's important that you discharge your duties without discrimination, meaning that bias regarding race, color, religious belief, national origin, sexual orientation, gender, or disability of any party, of any witness, or the lawyers should play no part in the exercise of your judgment throughout this trial. So these are called conscious biases. And when answering questions, it's important, even if uncomfortable for you, but it's important for you to share these views with us. Now, you've had a video that talked about implicit bias or unconscious bias, and that's a more subtle tendency at work in all of us. And we just need to be on guard and aware of ourselves when it comes to that. So this is just part of human nature, and it's completely understandable, but once you become aware of your own biases, they cannot play any role in your service as a juror. So, in our daily lives, we are required to make a lot of decisions all day long. And there are many issues that cause us maybe to make quick decisions based on generalities. And in making those, you might call those generalities biases or prejudices, and we apply those to keep moving in life. And it may be appropriate as a coping mechanism in your day-to-day life, but it can play no role here as a juror. You have to make sure your decisions are based on an open-minded, fair consideration of evidence that comes before you during this trial. That's who we're looking for. So, as I said, I'll be asking you some questions about your qualifications to be a juror. We ask that you look into yourselves, make sure what your answers are, bring forth maybe the uncomfortable issue that you want to say. But is there anything, none of you come in here without a background. We need you to have a background. You're part of this community, and that's part of your common sense we need. But is there anything in your life experiences or your personal beliefs that might have such a strong influence that would overcome your ability to serve as a juror? And that's what we need to know. We'll ask, not asking now. So I appreciate that you're ready. We'll get to that. But so just keep that in mind and look into yourselves for that. So at the conclusion of the trial, it's the judge's obligation to give you what the law is. And I'll be handing that to you in what we call jury instructions. And they're binding on you. So regardless of what you thought the law is, what you want it to be, it's what it is, and you shall accept it and work with that law as it is, as I instruct you. And then during deliberations, at the very end of the trial, when you're in there talking together about what to do, you decide this case by evaluating that law that I gave you and evaluating the facts that you've found proven beyond a reasonable doubt. And in that way, find the case. You have to decide whether the state has overcome the presumption of innocence and prove these charges beyond a reasonable doubt. So again, we're trying to find folks with an open frame of mind who are going to be on guard to their own personal biases. And before we ask all those questions, I'm going to put you all under oath as my potential jurors. So how we do that is have you all stand up. And then have you all raise your right hand. Okay, to each of you solemnly swear or affirm that you will truthfully answer the questions that I ask of you or I allow these lawyers to ask of you of your qualifications to be a juror. And I'll start with juror 1 over here. Will you take that oath? Please have a seat. Juror 2, and have a seat. Juror 3, juror 4, juror 5, and juror 6. All right, second row, I'm going to juror 7. Thank you. And juror 8? I do. Juror 9? I do. And juror 10? And juror 11? Okay, and juror 12? Juror 13? And then the back row there, juror 14. Take that oath. Juror 15? Juror 16? 17? Right. And you can be seated as I come through. Juror 18?
Yes.
Juror 19? And juror 20? All right, thanks, folks. So, how we doing listening? Everybody's doing okay? Hearing as much? I still see good. All right. So as I ask the questions that I'm going to ask, I'm going to refer to you by a number. And so you may all need to look down and figure out who you are by number. And I'm doing that. It's obvious. There's no way I can remember your names. And also it gives you a little margin of anonymity. And the lawyers will do that as well. They'll refer to you as numbers. So try and figure out who you are by number today. You are far more than a number. You're a very important part of this process. But I think that gives you just that level of anonymity that's appropriate here. So, and I'll ask questions, and if you're to say, yeah, I need to answer that, then you'd raise your hand and leave it up because I'll keep note, the lawyers keep note, they may follow up. If the answer is no, then you don't raise your hand. I suggest to you that you're going to be raising your hand a lot because you're going to go, I don't understand that question. Or maybe, or I wonder if they need to know this. Err on the side of spilling. Just tell us. We'll figure it out. All right. Let's see. First off, I'm Judge Kayla Wilcox. I'm Thurston County District Court. I don't think I recognize anyone. Anyone know me from before today? I don't see anyone. All right. Does anyone know Ms. Pritikin from before today? Don't see that. Ms. Groth from before today. Anyone know Mr. Edmondson from before today? All right. So we have some witnesses that we may hear from, and I want to see if anybody knows anyone there. Would anyone know a Dave Matthews Sr.? Nope. All right. Carly Joanne Schluter. Anyone know a Carly Joanne Schluter from before today? Nope. A deputy from the Sheriff's Office, Carissa Watson. Okay. All right. Any of you know each other from before today? All right, all new friends. Okay. Let's see. Anyone, so I'm going to ask kind of a series of questions about you in particular, then the follow-up will be any family or friends that you have. So you in particular, anybody involved in a court system or was involved with one, whether it's a state or another state. I see a couple of hands going up. Steve, keep them up there if you would. We'll get 5, 10, there it is. Okay, 18 and 9. Is there another hand over there?
Yes, question.
Okay, so wondering if you've been involved in a court system, either here or there, worked in a court system, judge, lawyer, clerk, anything like that. So I've got 6 and 8. Thank you. 6 and 8 and 18 and up 9. So you changed your mind there on the edge? Okay, 14 now and 18. All right. Let's start with you at 18. You started us out. So your association with a court system in that way?
Yeah, administrator, basically, for 6 years, several years in district court.
In Mason County? Okay, got it. And let's see, 9. What's your association? And you're still working for them? No, they're retired now? Okay, all right. And then Juror 8?
Public side, is it like working for,
Well,
or,
what comes to mind? What do you want to tell me?
well, I've been divorced.
Okay, so you had a lawsuit in court. You filed for divorce.
It was actually a domestic violence from my
Okay,
in child custody.
okay, all right. And that's not exactly where I was headed, but there's another question and you were told that, no, it's good. See, you might as well just start talking. So, let's see. So was that in this county?
No, it was out of state, it was Texas.
Okay, and how long ago did you go through all that?
That was, I got back before 2000.
Oh, okay, a while ago, 20 plus years.
Yes.
Okay. All right. And so did you testify in court about, was this all just about the divorce or was there also a criminal case?
Well, they were at the time is show. So the judge just asked some questions. And
So it's just the divorce portion and the parenting. Okay. All right. Got it.
well,
So a protection order or some
Yeah.
nature? Okay. Is that still in effect?
no.
Okay.
You know,
Okay, all right. Anything about that personal experience, knowing that the slim outline I gave you here of the charges, anything about that personal experience going to make you interfere with your fairness to one side or the other here?
I'm not sure.
Okay.
I'm honest, I am not sure.
So what are you not sure about? Can you voice that a little better?
That's bias about it,
Mhm.
but I don't know if hearing certain things might like trigger or revisit something within my situation.
Okay. That might re-stimulate some emotion. All right.
Yes.
And then you wonder if you're gonna have a clear head. Is that a fair way to put it?
It just might bring back up, you know, situations, feelings that I've had at the time, make me relive, so to speak.
Mhm.
So
So,
I just,
and with that bias, if it did happen, you're not sure, which way do you think you would be biased against? Which side? Both? One or the other? Okay. All right, that's
situation, you
okay.
know. Just, I'd like to be, that I wouldn't, but.
Okay. Hey. So I'm wondering if juror one needs some water.
Just my comment. So I'm doing that, this just single phase of.
Yeah. Okay. Well, if you need something, let me know. We got Kleenex as well. All right. So let's see, juror six. There you are. Hello. So your association to the court system. So you did a pleadings and called folks and arranged witness interviews and things like that. Okay. And your firm did criminal defense. And did they work in folks who had been accused of domestic violence crimes? Okay. All right. And are you still there? Okay. All right. All right. And then, so family or friends? Do you have any family or friends who are working in the legal system in that way? Great. Hands up if there are any. See 6 and 15 and 18. Okay. 18. All right. Juror 6, who do you know? Oh, 8. Sorry, got that wrong. 8. Okay. Is he presently working? Okay. Which agency? Okay. What does he do there?
He's been a detective, but he is a corporal.
Okay, so he's a detective, so he's been there a while.
Yes.
Okay, all right. And do you hear much about his work?
Occasionally, and usually it's like home for lunch on the radio, and then they'll have to like run.
Okay. All right. All right, and then let's see, 15, I think you knew someone? I think I covered it. All right, are they all around the nation or here in Washington? Okay, anybody local in Thurston County? Okay, and what do they do here in Thurston County? You know? Okay. Okay, so an attorney at City of Olympia? Okay, and haven't talked to them in a while, so you're not quite sure what they do day in, day out, or? Okay, that's enough to know. All right, and then 18, there you are, hi.
Yes, several.
I bet.
Solid. Thurston variants, Mason.
Okay, so dispatch and working in juvie, working in district courts, law enforcement as well. Okay, but you don't know who we expect we may hear from today from Thurston County Sheriff? Okay, all right. And let's see, then, and, oh, there's another, 9. Family or friend, just anybody you know. Anybody you know. Doing. Okay. And still working with, yes, no, okay. Okay, all right, got that, thanks, that's exactly what I was thinking. All right, so, yep, there's 6.
My husband was a corrections officer for in Stafford Creek.
Okay, you see. Is he still doing that work? Okay, all right. Anybody else? Okay. You're 10.
I was married to a police officer, but a while ago.
Okay,
Yeah.
okay. That's a while ago. We'll give you that one. All right. Don't worry. All right. So then you yourself, I've got a couple of answers already, but you yourself involved in law enforcement, whether it was civilian or military, commissioned, non-commissioned, any law enforcement background. Okay. 2 or 3?
Yeah, I was law enforcement in the United States Air Force, 4 years.
Okay. And what did you do there? What kind of things day in and day out?
Was in the stuff you see on front gate duty, missile security, bit of patrolling, a lot of training.
Yeah, lots of training. Did you have the authority to arrest people for crimes committed on base or off base?
Yeah,
Okay. So did you have to testify at any time about in a court martial or anything of that nature? Okay, so, all right. And then family or friends, we've heard a few folks already tell us they have family or friends or no folks in law enforcement, but anyone else? After 16. Okay. Okay, so folks that you knew when you were serving, you don't know the sheriff that I mentioned here, that didn't ring a bell? Okay, all right. So you've heard the charge, the allegation is a violation of protection order or restraining order or no contact order. They're called all different things, but, and something called cyber harassment. And have you been charged with anything like this? Ever had a charge laid against you by a prosecuting attorney, not just someone pointing at you? Okay. Family or friends that you know may have had a charge similar to that, like that. Okay, juror 6. What do you know? And juror 15. How long ago was this? Okay, is it still in effect?
It was in effect.
Problem now. So you went to court, you testified about that, you received that protection order, and it was in effect for a couple of years before you died. It's okay. All right. Well, anything about that personal experience is that going to get in the way of your ability to be fair here? Wouldn't be able to put that aside and listen fairly to both sides. Okay, good to know. That's all right. And then 15, I thought I saw your hand go up.
Yeah. It's good. I think that.
Okay. Do you know how long ago this was? Okay. Did you know anything about it other than being told about it in the family or? Okay. All right. So did you have to testify against your brother? All right. And that's no longer in effect as far as you know? Oh, all right. So this was about, you said quite some time ago. All right. Anything about your brother being accused of that, having a protection order laid against him by a court? Anything about that personal experience going to make you wonder about your fairness to one side or the other here? Okay. And what do you thinking about that? What? Pardon?
I think that
Are you able to put that personal experience aside, or will it flavor everything? Okay. All right. Okay. See anyone else? Family or friend? Oh, 18? Could be or not. Okay. And years ago means how long ago do you think? 20 plus. Okay. And were you a witness to all that?
I'm not.
Okay. And okay. Did you have to give any testimony? Okay. And do you know if there was any protection order issued or anything of that nature? Okay. Anything about that experience with your sister going to make you wonder about your fairness, one side or the other? Okay. All right. Yeah, let's see. So at the end of, as I said, at the end of when all the evidence is in, I'm going to instruct the jury, whoever they are, about the law in the case. And I kind of told you before that you have to accept it, whether you like what the law is written by the state ledge or you don't like it, but you have to accept that that's the law, whether you like it or not. And you have to accept my instructions. You have to work with that in your deliberations. Now it's fair. Luckily in America, we get to disagree. And it's fair for you to disagree with that. I just need to know if you disagree with the law that I instruct you on, will you then not follow my instructions? Is that something that won't allow you to do that? Or even though you might disagree with the law, you'll still do that duty and you'll follow the law as I instruct you. So anybody not able to if they don't agree with the law as it's written. Right? Got a good commitment there. So this kind of going to, juror 5.
Charters.
Mhm.
And about 10 years ago, I had an issue with a neighbor.
Mhm.
actually law enforcement that showed up that he called for me to get a protection order against him. And I mean, it was 10 years old and they moved and it.
Did you go in? So you followed up with the court and got a protection order? Okay.
The judge said you need to go Monday morning and get a protection order. So,
And so that was granted
yes.
and you had to testify or tell the court?
So I did
Okay.
violate. But
Did you have to ultimately, you went to court? Okay, and you told the court something and they issued that order. All right, but then since that order was issued, the folks moved and it was a done deal. Okay, all right. And anything about that experience to make you wonder about your fairness to one side or the other?
I could say no. Yeah, I don't think. I mean, I didn't get it because I was afraid. I got it because they told me to do it. They were very familiar with this person. He had lots of run-ins with law enforcement, and so for me, it wasn't to. I just did it because they recommended it. I didn't
Okay.
feel like I was at first.
So you can put that to the side. You've had that experience, but you won't let that color what you're doing here. Okay, so all right, and then let's see. So, another, 14. Good question. It's all the same. Let's just say an order that restricts someone's contact with somebody else. Does that bring up a issue? So I would presume that you were kind of involved with that, being the parent. And so, do you know what court, was that locally here? Okay, how long ago do you think that was? Okay, so, not 25, 6 years ago now, yikes. So, did you have to testify at that event or give? Okay, you didn't write anything down or give it to the court? Okay. All right. And so the court did hear from you in that way, it sounds like. All right. Anything about that experience that's going to make you wonder about your fairness one side or the other here? No? Okay. All right. Then, any more? All right. So I don't need your full medical history. I don't want it. But I'm just trying to figure out if there's something that I can accommodate or not. You'll be sitting and I like to take breaks every hour, at least, every hour or so. And I always check with the jurors and see how we're doing. And I don't interrogate anybody about breaks, just say we're taking one if someone needs one. But is there something like we need to stand up and stretch, you need some water on a periodic basis, you have to take a medication, something that maybe that I can accommodate a lot of that, but maybe there's something I can't that'll get in the way of your ability to focus. That's what I'm talking about. So 18.
Here's a few weeks ago. Long period of time.
Okay, how do you manage that? It's just 2 weeks ago. Okay, and how often do you like to do that? Okay, I mean, if you need to stand up right now, go do it, but don't go too far.
Find out about some must send a post office.
Okay,
Ahead of time.
that was the next question you're foretelling. That's the other thing too, is do you have something that's coming up? I anticipate that we should be able to get all the evidence in by tomorrow and to the jury. And then the jury decides how long you talk about it. I don't have anything to do with how you decide how long. We usually get things done in a couple of days, meaning usually by Tuesday evening, you're off and away and we're done. But I need to know, is there a medical appointment that you can't reschedule? I know they're hard to get. So they're hard to get. And so I'm gonna kind of think about those, but you got tickets to, I don't know, where do we want to go today? Let's go to Spain. You got tickets to Spain, you're gonna move out and lose all your money, Wednesday, are you on your way there? Is there some hardship? Do you have somebody at home who is vulnerable and you had to leave them alone and it's not safe, it's dangerous, you're the one who has to be there, something like that? Any kind of hardship kind of thing that I need to know about. So 18, you've got some appointments coming up Wednesday and Thursday. All right, and they're post-op, and you just 2 weeks ago you had this happen. Okay, good to know. So Wednesday morning, Wednesday afternoon. Okay, all right. Anyone else? Anything? Any tickets? All right. 1, 8. Let me just write down the numbers so I can keep track. 1, 8, and 13. Okay, so I'm sorry. So 1. So you're hacking your head.
Roll it and
Okay.
about as as it was.
Okay.
Anymore, it's just hanging around.
And so this is kind of how it is all day long for you now,
It just kind of starts and
and then you're done for.
so it just will die down again and never know.
Okay,
Looks when it clears itself, I guess.
all right.
I feel fine. It's annoying.
Just the leftovers. Okay, and then you're 8.
I have an appointment to because I have a wedding for my son.
Mhm. Gotta look good. So Thursday afternoon?
All day.
Okay. Okay, Thursday wedding stuff. All right. And when's the wedding?
It's actually it's gonna be in El Salvador.
29.
Okay. All right. And then let's see, who's it, L5 and then just
Every Friday, I have my 2 grandsons. Early in the morning, and I take them to school.
okay.
My son and daughter-in-law both work really early hours.
Caregiving on Friday. I
Yeah.
can imagine they're still gonna be here. Okay, that shouldn't be a problem. 13?
It's not about missing time, except I'm a fully commissioned sick. I go out and be called. They
don't get paid. Yeah.
don't miss work.
Yeah, we don't give you a whole lot to do this. Okay. Got it. All right. All right, I think that's all from me. I'm gonna turn this over to Ms. Pritikin, and then Ms. Groth will have an opportunity. So the floor is yours.
We'll get a little bit closer. So who thinks that they're going to be a really good juror? Like this is something you really have been looking forward to doing. You always wanted to be a juror. There's some people at the last trial, somebody actually raised, see, you guys thought I was nuts. Okay, you're number 9. Why, is this something that you really wanted to do? Okay. Okay. And now you're retired, right? And do you think you'd be able to separate some of those recommendations that you made in your head from maybe what the defendant's being charged with? Okay. Opposite question. Does anybody, I mean, number 13, I sort of got the general point of this from you, but does anybody absolutely just never, ever wanted to be here, don't want to be here, would rather be anywhere but here? But you know what? I'd rather know that and know, the reason why. So wait, take your hands up because I will call on you in order. Okay, so I'm gonna start in the front. This is where everybody raises their hand. We have a problem. Okay, number 5. Oh, well, congratulations. No,
So I'm not gonna have my grandkids on Friday. I work 4/10s and Friday's my day off. So I was like, I don't wanna have to be there on my day.
I really don't think we'll be here on Friday, but okay. That's me like cursing us now, right? Okay, number 6. Okay. Who else? Okay, number 12. So this is sort of something you were just not looking forward to. Oh, good, yes. Okay, who else had their hand up? Number 11. Let's see if I can do math in the right direction. Yes. See, and I'm a dog lover, so okay, this is a problem. So the dogs would be alone all day? Okay. And nobody's home that could let the dogs out? Okay. Okay. Who else had their phone? Number 18?
Yeah, that's most of the comfort level and the. Too far. Just let's be with.
Okay. 2 weeks after the back surgery is, okay. And number 13, should I take it that you would have had your hand up had you not told us before?
Yes, because it is a hardship for me financially, but personally, I love it.
See,
It's my.
it's fun. Okay. Okay. It's good to know. Okay. This is where I have to call on people by number, and I was the kid in school that hated being called on, so I really apologize for doing this, but I kind of have to. So I will call on you by number, and you can squirm, and I will just watch you squirm, and it's fun. So if the state proves somebody broke the law, but you thought the law was stupid, some laws are stupid or unfair, do you think you'd still be able to follow the law? Number 2. She's like, no. Okay. Yeah, so say somebody broke the law, the judge reads you the law, you're like, oh my God, this is just a really dumb law. What do you do? Okay. And if you knew the defendant broke it, and even though you thought it was dumb, you'd still be able to follow the dumb law? Number 4. Number 7. Even if you thought the law was really, really dumb? Okay. Okay. Do any of you own a business? Number 7, you own a business? And do you get reviews online for that business? No. Do you have a website? You just have the business license, okay. Anybody a professional where they get reviews online for their work? Number 4. Hang on. And you get reviews online personally?
Like notable.
Okay.
So,
And do you feel like people read those reviews that you've gotten?
Yes.
Do you feel like those reviews reflect how much new business you get?
Hope so. Think so.
Have you ever had a situation where somebody attacked you personally in those reviews? Have you ever had negative reviews? Anybody else get reviewed online? No. Okay. Number 4, how would you feel if somebody didn't write about your business online, but they wrote about that they just didn't like you?
I really expect these days to place for,
Yeah.
not be surprised.
And what if they wrote very personal things multiple times? Do you think there's a point where maybe it would tip over and go too far? What would you do if somebody was saying, hey, number 4 is a horrible person, he runs a terrible business, never ever go to his business?
I know that I can put it on things online, and I would certainly try and be objective and respectful. I wouldn't go the negative route with it, and just fight back kind of thing. Not my way.
Along those lines, number 10, like, she found my number. Is there any language that would make you uncomfortable to hear? Like if you heard vulgar language that I have to read out loud for a reason, would that make you really uncomfortable? Good. Is there anybody, and I should probably open this up, that would really not want to be on a jury where you have to hear very vulgar, obscene language? Sitting up there going, yes, yes, okay. Number 6, and who else? Number 8. I'm not saying this is going to exclude you. I'm just making a note of this. Everybody else is okay. You're not going to be mad at me personally. Okay. Do any of you write reviews for businesses that you go to? Number 12. What kind of businesses do you write reviews for?
I don't get them often. I just got really mad at the other one.
When you write, so and that was going to be my next question. When you were writing a review about the casino, was it about an individual person or was it about the? Have you ever written a business review about an individual person that was more of, say, a personal attack? Number 13, have you ever written a review on a business site that was more of, say, a personal attack on a person? Number 10 again. If you were, say you're reading through Yelp, you're familiar with Yelp, where there are reviews of businesses. Say you're reading through there and you see a review of, say, a haircut place, and they're attacking the hairdresser personally. How would that make you feel? Okay. Number 7. Say we're looking at the reviews of the hair salon that you're about to go to, right? And you see a post by somebody. Would you assume that that person is who they say they are? Like, say it's signed by their name. How would you know if that's their accurate, if that person actually made that post or if they're posting under a pseudonym or something? And how would you, it's fair, how would you prove it? Or what would you need me to show you to prove that somebody posted something? Okay. Okay. Number 1. Same sort of question. You're on a review site of your favorite restaurant. You see a post by Susie Q. You're like, hey, I know that person. What would convince you that it's actually the Susie Q that you know? Okay. And what would Susie Q have to say to convince you that she posted that? Okay. And say say you weren't able to talk to her, would there be any other clues from the post that you might use to figure out that it was Susie Q or not Susie Q? Okay. Number 3, same question. You see a post, you think it might be your friend, you're not quite sure, your friend's name is John Smith, you know, common name. How do you know it's the right John Smith? Okay. They're on vacation in Spain. Judge Wilcox sent them to Spain.
Would assume it's the confidence.
Would there be any contextual clues in maybe in how they're writing or anything like that that you could use?
That could be. I'm from Philadelphia, so we have our own language. And like,
And sometimes does that type of language come across in writing? Okay. Do other people have friends where, you know, you don't even need to see their name, but you know that that message might be from them just because of the style or words you use? I see a bunch of people nodding their heads. So maybe if you saw a post online, it was some forum, you'd be like, oh, that's my friend Stacy, because that's just how she writes. Number 12, you're nodding your head. And this is me trying to do math. I'm like, okay, you don't have it. Yeah, number 11, I see you covered up your sticker. See, this is a problem. Do you feel like if you had a history with a person, maybe you dated them or you received other?
Injection?
Too close, but that's what she's saying.
I'm gonna allow the question. Go ahead.
Okay, so say you have a history with a person, maybe you were married to them, whatever, any kind of history with a person, you knew them for a number of years. Do you think maybe you'd be able to recognize their writing more than if it was a stranger? No? You don't recognize anybody's writing?
I don't read them.
So you're one of those where they told you not to read the comments or reviews and you take that to heart and you don't read them. Okay. No chance of reading. Okay, fair enough. Say somebody sends you a letter in the mail, they don't sign it. There's no return address, you're ripping it up. Okay. Fair enough. Number 1. If you personally dislike somebody, would you post something online about them? No further questions.
So Ms. Crowe, why don't you your opportunity?
Hey guys, all right. You guys learned about bias, and so I kind of want to start there. Something about me, I love cats. I have a cat. I think they're the best pet you can have in the universe. Who feels strongly about what I just said? See number 11. You have dogs. I figured you were gonna get me on this. Yeah, so you feel strongly about that. You think dogs are the best animal in the universe, right? these are examples of biases. You love dogs, I love cats. It's just who we are as people. Yeah, exactly. So can anyone maybe say why talking about bias is important? No, no one wants to talk about it. That's fair. Okay. Does that make it, is that weird or uncomfortable for you guys to talk about bias? No, I see you're shaking your head. Exactly. Thank you. So does anyone think they're gonna have a hard time being honest or vocal about their biases? No. Okay. Does anyone have any biases that they think would make it hard for them to be fair and impartial when considering this case? Number 6, you mentioned that, yes. Yeah, that's fair. And is there anyone, like maybe your best friend, anyone who could change your mind about that feeling? Right. There's nothing anyone could say, anyone could do that would make you change your mind about that. Okay. Okay. Yeah, that's fair. I understand. That's fair. And I thank you for admitting that. Does anyone else feel a similar way about it? That there's, yes, number 8. Mhm.
Oh,
Yeah, so same question line. There's no one, your best friend, your kid, no one could change your mind. No? Okay.
right.
Okay. That's fair. I thank you guys for sharing that and being honest about that. All right. Okay. Kind of moving on. You heard Judge Wilcox talk about the presumption of innocence. Does anyone relate to the phrase or feel a similar way about Mr. Edmondson is here because he committed a crime? Does that make anyone feel a certain way? Or 16? That's a fair point. Thank you. And then I thought I saw another hand for same thing. Okay. Yes. Okay. That's good to hear. Okay. Did anyone maybe have this thought when you walked in? I wonder what he did wrong. No one? One? All right. Nice. Um, okay, kind of going on to the right to silence. So would it be important for people here to see the defense or in my side present evidence to show that Mr. Edmondson did not do what he's accused of? Do you need to see me or Mr. Edmondson's case present evidence that he didn't do this? Okay. Does anyone need to see him testify for you to find him not guilty? Okay. Okay. Kind of shifting gears again, you're going to hear testimony from a police officer. Officer jobs are to protect us and investigate, but my job requires me to ask them difficult questions. Does anyone feel uncomfortable with me questioning the officer about her choices during the investigation? I know number 9, you did investigations. So if you were on the stand and I kept grilling you about your investigation, would you be upset about that? Yeah, if I was questioning you or one of your colleagues about an investigation you guys had done, would that be hard for you to listen to? Okay. Cool. Let's see. Does anyone here feel like they will weigh cops' testimony more or better than a layperson testimony? I know, I think 18 said you had relatives who were cops, is that correct? Many friends who were cops. Relatives to dispatcher, okay, got that a little mixed up. Do you feel like by having friends who are cops that they're more trustworthy than, say, a layperson? Okay. And number 5, you said that you had an officer come to your house and kind of encouraged you to get that protection order. Do you think in listening to an officer's testimony in this case that you would inherently trust them in this situation?
Just because they're an officer?
Yeah, just because they're an officer. Okay. So you're in, one of the charges is cyber harassment. So you're going to hear testimony from someone who says they were experiencing cyber harassment. Has anyone here experienced cyber harassment or cyberbullying? It's more of a my generation thing, but how about any family members who've experienced cyber harassment or cyberbullying? No? Okay. Yeah. Any more questions? All right, I think that's it. No further questions.
Thanks, Ms. Grove. So, folks, then, let the attorneys kind of cogitate a little bit here. They're gonna come up and join me here. You can't leave, but you can stand up where you are, stay right where you are, so you can figure out where you are. You can't talk about anything we just talked about. So figure out something else. There's lots of other ideas. 5? Sure, we can, Mindy can get you a thing of water. Anybody else want a water? A cup of water? No, Ms. Grove?
Oh, no.
I'll have Mindy take care of it. That's her
Okay.
job.
You try to make
You need waters. I guess we'll bring a few waters out. Looks like 3 or 4 or 5. Anyway, you can feel free to stand, sit, just if you chit chat about something completely else and keep it low because we're going to be talking here on the record, but don't go too far from your seat. All right, so on over in your client. All right. Wait, so we keep that for me. This is a recall of Robertson. Are you gonna still read it? And then it'll. And then. So folks, I need you to stay close to your chair and and quieter, a little quieter and get back to your chair if you would, please. Can't have you wandering.
Up to white.
So folks, again, I need you kind of close to your chair because I'll be looking back to kind of figure out who's where. You don't have to sit, but don't wander off. All right. So maybe here, I'll keep turning to her, make it seem obvious. Turning to her to say, but we're right. So right now, we're gonna do a pause. And if the time that you need some private time with your client, that's fine. You can send it into the journal and you can talk and come back. So if you need that, that's fine. So the full crowd, I'll start with Ms. Pretty Kim's 1 through 20, and pause there. takes up. So then, Spritikin, any?
I don't have any.
Number 8, on the similar vein of number 6, had a personal experience. I again asked her if she felt like anything could change her mind, and she said the personal experience would be clouding her judgment.
So number 8, she said she wasn't sure if she could be spared, but she didn't come right out. You know, said that, you know, she might get treasure. I don't know. It seemed a little more wishy-washy. But it didn't seem like it was as important to her things. I've got the feeling that she's still able to have some way.
Wishy-washy is a good word. She said she wasn't sure and when pressed. Right to. If not, sure.
She was, I questioned her after I questioned number 6, and she said along the same lines as number 6, in terms of she agreed with the personal connection and felt that that could be something to cloud her judgment. She wasn't super confident in it, but she was in very much agreement as to what number 6 was saying when I spoke to number 6.
Number 6 is really.
Yeah.
Yeah.
So the cloud of judgment, it's just too much for me.
8, I'm not yet there. Questions didn't get me to for cause. Let's try to hate it. And any. In this program.
Not before call.
So I have some that I'm thinking are hardship.
Mhm.
18, I think.
Yes,
Looking at them. Okay, his,
making my back hurt.
all right. Yeah, I don't think he can focus. So then I'm gonna take 18 off, or causes of hardship, I guess we'll call that. Where do we have that? Yeah. And then my concern as well, when I asked for hardship, talked. The dogs in the garage, number 11.
Is that? Yeah, 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 I think so. But
Anyone's point of view on that?
it was pretty.
He wants to be with his dog.
Well, I'm concerned that could be a long time, and if it
Yeah.
pressurizes him to come to some.
Yeah, no, I agree.
Yeah.
I
Yeah.
Thing.
11.
11. So I think that's a hardship because he'll be excused. The others, I think I can accommodate.
I have another issue that was a potential for cause for number 13, but I think that's sort of an issue that keeps coming.
I know it's an unfortunate part of doing your civic duties,
And
and that's not a good cause or basis
Yeah, yeah,
for.
it's just how much at what
Yeah.
point. And
Yeah, it's one of those.
yeah, no, I understand.
Those are hardship. Trying that, see what happens. All right, so we're on trees. Each side and we're turning into here first. Who is our Zoom six?
Wait, what about one?
No,
No, we didn't get. No.
no.
Nope. Wow. Nope. So whatever
You did.
here's for cause on. Six. On 11, yeah, for cause on 15. That's why we really vote for her to. Why we do this as a group. Okay, so we're 1 through 8 minus 6. 1, 2, 3, 4, 5. And 7. So our 6.
Yeah,
Presumed
I don't do
six.
7.
Don't do that. Okay, this is our presumed 6. And there's Pritikin within that crowd, the preemptory. Number 2. Right? State first. Preemptory, number 2 is stricken, so that takes us down to 8. Okay, so through 8, this crowd, any preemptory decks or something.
8.
Okay. 8 and preemptory. Got one. Okay, no, it's pretty good. 7.
I'll object to that on GR 37.
The reason.
Okay, yeah, let me hear. that.
Sorry.
That's all right. Appreciate you on it. Great.
Yeah, so objecting because he said that we absolutely only say find situations involving internet is actually by the person. Authorization of states, we're talking about the authorization of internet posts. Flat out doesn't believe that you can give authorization.
And then, you know, what we're working on here. And fill 'em. But he does look like a person who was a person. So my job here is to determine under 37 whether any reasonable objective or observable would think that this peremptory is exercised. So,
I think he said that wasn't necessarily nothing that he can prove. He wanted to see evidence. And then there may be instances where that evidence could be fake, but he was simply saying, I want to see evidence besides just one thing that's telling me that this is his.
That's, I asked him, and he said there was.
so I'm gonna err on the side of JR 37 and not exclude the civil rights. Began saying that, and this is all perception, most of it is a personal color. I have no idea how that 37 works. I see this person of color, one of the few on this group. So he'll remain. So we're still. Oh, no, it is a big.
Wait, do I get another?
Second grade.
Okay.
I get one second.
Just said it.
Move your chairs around wherever you like. All right, folks, thank you for your patience. Oh, thank you. And Ms. Groth, you can hand me your whole packet.
Yes, there you go.
All right, thanks again for your patience. We picked the juries. The folks staying with us will be just stay right where you are for now. Juror 4, you're staying. Juror 5, you're staying. Juror 7, juror 9, juror 10, juror 12, juror 16. And so the rest of you, you've now served your duty to the courts here in Thurston County. Thank you very much. Can't do this without you, and we sure appreciate your responding to your summons for jury duty and doing this with us. So where do those folks are excused, do they need to go anywhere? They do need to? Oh, I thought you were relieved at that. All right, well, you're everyone but I called off. You can be on your way. Have a good afternoon. Apparently you do have to call the jury line back and see if you get picked again. So I thought you were relieved of it. So on your way, and then folks who we picked, just stay in your seats. Thanks so much again for your service. At 11, you have to go. You're out of here. You're on your way. You don't get to stay. All right, and then Whitney's gonna get you settled over here in our spot. And then I'm gonna give you about 15 minutes worth of instructions. We'll take a break. So Mindy will get you organized. Turn over there. Stand up again. I'm gonna put you under as my jurors. So raising your right hands. Do each of you solemnly swear or affirm that you will fairly try the issues in this case according to the law that I instruct you on and then the facts that you find proved? Do each of you take that oath? Yes. Thank you. Please have a seat. So couple of just kind of tell you what happens first, second, and third, and then we'll take a break to refresh, and we'll come back and do some openings, and we'll get you out of here by 5, I'm certain. So what happens first is just that we'll hear opening statement from the prosecuting attorney, and she'll outline the witnesses, the evidence, the information she expects to present during the case in chief. And then at that point, Ms. Groth can either give an opening statement then, or she can save it for later. It's up to her, and I'll inquire at the right time. After the opening statement, then the prosecuting attorney, Ms. Critican, will then present that as that evidence, that testimony, witness testimony. Evidence is anything. It can be witness testimony, it can be physical objects, pictures, it can be audio recordings, video recordings, somebody's left shoe, it can be anything. So evidence is just a big word for all the information that the lawyer wants to get to you that thinks it's persuasive. So, and so the prosecuting attorney will do that first when she's finished. Then Ms. Groth, on behalf of her client, will have the opportunity to do that. But you have to remember my earlier instructions that the presumption of innocence means that the defendant doesn't have a duty to present any evidence, no duty to testify, no duty to call witnesses. So if there's a witness will be here testifying, and it's proper for each side to cross-examine or ask their own questions of that witness as well, and we'll allow that. So they'll be potentially cross-examined. And then we have all the witnesses, all the evidence, all presented. Then at that point, I'll present, advise you as to what law applies here. And you're going to have that in writing. And courts are old, so I'll be reading them to you because the Supreme Court says, but you've got it in hand and you'll take those instructions into the jury room with you. We'll get you oriented here. And once I instruct you as to the law, then we'll hear closing arguments. And we'll hear first from Ms. Pritikin, hear closing argument from Ms. Groth. Since Ms. Pritikin is the state, she has the burden. So she's allowed to be heard last. So if she reserves time on her closing after Ms. Groth, then we may hear from her again, and that's proper. After the closing arguments, then you're going to be into the jury room, and I'll tell you this is now when you start deliberating. You start talking about the case, figuring out what your verdict might be. And at that point, you would pick one of you to be the presiding juror, and that person would preside over your discussions about the case. Deliberations are really just your discussions, what that means. And we'll ask you to deliberate in order to reach a verdict. And that's a decision. And until you're in the jury room for your deliberations, which won't be a surprise, we make it very clear. Until then, you're not to talk to each other about this case. You're not to compare notes. You're not to talk about the issues. You're not to talk about definitions or the parties, not until I allow you to do that. Right now is just the evidence collecting. So, and that means no discussion means as well, you're not going to look up things. You're not going to, text message. You're not going to blog. You're not going to internet. And so we're going to talk about that issue of social media. When you're on a jury, a lot of people, at the end of the day or the beginning of the day, they update their social media and say, this is what I'm doing today. This is what I did today. This is what's going on. You're not to do that. It's part of your oath. Because guess what happens when you do that? You say, oh, guess what? I got picked for a jury in Thurston County. Even if you don't say Thurston County, they know where you live. All of a sudden, people are digging through Thurston County. Oh, I wonder what it is. I'm going to send them all this information. And it may not be right. And it certainly isn't anything that you received in this courtroom during the proceedings. Because all you're to consider is what you received in this courtroom during the proceedings. So very innocently, if you go online and say, guess what, I got picked for a jury, all of a sudden you're going to get avalanche with information that is not part of this case. I mean, we'll have violated your order, and then we'll have to declare a mistrial. And then all this money, expense, and pain and torture has to happen again. So do not go to social media and update things. Just be quiet. You will be relieved of my orders in about, probably by tomorrow night, I'm guessing. You're going to be relieved of these orders. And then you can talk about it in any way and to anyone or not. And it'll be entirely up to you. But for now, radio silence. All right. Because it's your duty to decide the case based on the facts you find proved here during the proceedings and the laws I give you, not an outside issue. Again, as you've heard us say, you have to accept the law for my instructions, and we'll put that to writing and we'll make sure you know what that is. And it's regardless of what you believe the law is or what you wish it were, what you hoped it was, it's what it is. You have to accept it. You've already said you would, so I appreciate that on that. So you apply the law and you apply the facts that you find proved beyond a reasonable doubt to the law, and in that way you decide the case. And again, the only evidence you're to consider is what you hear here in court, exhibits, witness testimony. So I caution you when we have a witness here to listen carefully. And so I'm going to need you to help me make sure you can see things, you can hear things. If you can't, raise a hand, don't be shy. Let me know. Can hear, can't see it, so that I can rectify that right away, because rarely, if any time, will testimony be repeated for you. And so I want to be sure you get it here when it happens. All right. And yep.
Can we take notes or?
Yep. You're foretelling what I was going to say. She's jumping ahead already. All right. No, you can. And we're going to give you a pad and a pen, and I hope the pen works and doesn't let us know. But because you're allowed to take notes. And I'll get to that more particularly, but just also a cautionary tale here, the lawyer's remarks, their opening statements, their closing arguments, their remarks here are intended to help you apply the law and but their statements, their closing arguments are not the evidence, nor the law. And so the evidence again is the testimony of witnesses and exhibits that I allow to go with you back to the jury room. If anything is said by a lawyer that you think is in conflict with what the law is I instructed you and the facts you find prove, then you disregard it. You're going to hear objections made by parties to another. A lawyer may ask a question, another lawyer may object, and that's perfectly appropriate. And in fact, there may be a duty to object. Now, the objections shouldn't influence you. Don't draw any conclusions. Don't make any assumptions about those objections. And then when one of the duties of me, I'm the trial judge, I have to decide what evidence by law is allowed in or admitted and allowed to go to you. So I make those decisions. Don't consider evidence that I haven't allowed in. You know how this works is, let's say there's a photograph that's offered by one of the attorneys, and I'll decide whether under the law it's allowed to be seen by the jury, if it's admissible. And it's not just, oh, I guess so. There's a whole stack of law that tells me whether that's allowed. And so that's what I'm applying. So don't be concerned about the reasons for my rulings. And you're not to consider nor discuss anything that I don't admit, or if I tell you to disregard something, you will. Further, our state constitution prohibits me from making a comment on the value or weight of evidence, because I'm not the trier of fact. You are. You're the ones doing that. So I will not intentionally, in instructions, any way, give my personal opinion about the value or weight that you should give evidence. If you think I have, though, at any point, then you're to disregard that. All right, so you've met Mindy. She's going to help you a lot with logistics. Don't ask her legal questions. Don't ask her definitional questions. It's like, don't put her in that spot. She can't do that. Again, you'll be allowed to take notes, and notes are to help you remember. They're not to replace your memory or the memory or notes of your fellow jurors, and you shall not show them to each other until you're in deliberation. They will be kept, so I suggest that when you get your notepad, the first page, just put some sort of mark on it, flower, whatever you like, so that you know this is your notepad. And then the next page you can start with your notes, because we're going to grab those up when we take the lunch break, and they'll stay here. And then when you come back, we'll give that pad back to you if you decide to take notes. Just make sure that they don't get in the way of you hearing and seeing everything that you need to hear and see. And those would be shredded at the end of the case. No one's ever going to see them. They'll be shredded. They're not part of the case file. So you'll get oriented here. That door right there is the door to the jury room, and it has a door on the other side that goes into the public areas and to the restrooms. Don't ever come into this courtroom unless you're escorted. Don't come in through those public doors. Don't come through that jury door room. Don't ever come in here unless you're escorted by Mindy, staff, court staff. I might do it. But that's because a lot happens in here that doesn't have anything to do with this case, or might have something to do with this case, but it's not part of the proceedings for you. And so you stay in the jury room. Also, I'll ask that you try not, when you take a recess, like off for lunch, I'm going to ask that you can stay in the jury room and have your lunch if you so want to, but otherwise, don't hang out in the common areas here, because you're going to put yourself in a spot that you're probably going to overhear something. Maybe it applies to this case, maybe it doesn't. You're going to possibly run into witnesses, defendant, and lawyers. And as always, I tell the lawyers here, and they're really used to this, is they're under my orders not to have any contact with you at all. And it's their responsibility to make sure that, Ms. Groth's client, that the witnesses that the state brings, that they have no contact with you in any way. They're not being rude. They just are under my order. And when this is all over, then everybody can talk to each other. But until then, do not approach lawyers, witnesses, defendant, even with a fair, where can I go have lunch? Do not put them in a spot. So, so the internet, we're going to take phones, we're going to take smartwatches, anything that you can connect to the internet while we're in session, we're going to take it from you. At lunch, we'll give it back. When you go home, we'll give it back. But you're not allowed to have anything that connects to the internet in session or in deliberation. So, any pads, anything. Decide if you want to bring it with you. Don't bring it with you tomorrow. You can live without it. And of course, if you've got something going on and you need to be in touch with the outside world, somebody, a kid, elder, somebody needs you, we can work that out, make sure that you are in touch with them, even though we'll have your phone. So just let Mindy know and we can make a plan if that's so for tomorrow or later. So we're not going to cut you off entirely, but you can't have them while you're in session or deliberation. All right. So I'll ask for now. Like I said about the internet, don't update your social media. Don't go to social media for now and tell everybody that you're on a trial. Your family, your friends, your coworkers, in person, you can't talk to them about all these things or anybody. You can't. And so you're going to tell them, there's like, wow, what happened today? And say, well, I can't talk about it. Tell you all about it later. Under court order, can't talk about it. I'll tell you all about it later, because you will. You'll be allowed to talk all about it later, just not now. So don't. That's what you say to those folks. I'll ask you to kind of avoid outside sources like all those talk shows and lawyer shows and all those kind of shows tonight. I watch a penguin show or something, pick something else tonight. Because, I'm trying to avoid magazines, everybody gets newspapers anymore, but, try not to go look at criminal things for the next night or so. Just kind of stay out of it all so that if you're going to, and also don't, as I said, don't look up any people, any words, any law, anything. You're going to hear soon where this is alleged to have occurred. You won't give that any more attention than you would have given it yesterday where you knew about it. So if there's an area that you travel through naturally to go home after you hear that, then you won't stop and inspect. And so importantly, you don't try to determine information on your own. It will be given to you here in court and by me. So if anybody tries to come up to you and give you information about this case, the people in the case or anything, don't discuss it among yourselves. Tell Mindy, this is what happened. And then I will talk to the lawyers to figure out what, if anything, has to be done. All right. So just ask you to maintain an open mind. That's what I speak to you for. Don't form any firm or fixed opinion about anything. And until you've got the entire case and you're all together and you're discussing it, that's when you form those opinions. So as jurors, you're officers of the court, under oath, you're officers of the court. Thanks for your time and energy. Whoops, you can pick that up. We ask that you reach your decision based on the laws I tell you, based on the facts you find proved. Importantly, not on sympathy, not on prejudice, not on personal preference. So that to ensure that everybody gets a fair trial here, we ask that you act with that earnest desire to reach the proper verdict. So we're going to take a quick break. And so it's called a recess instruction. Every time we take a recess, whether I throw you into the jury room for us to discuss something and then bring you back out, or it's lunchtime, or it's overnight, which we'll have, that you don't discuss any of the issues we've already discussed. You don't discuss the people, anything with each other yet at all. So you're not in deliberation. So talk about everything else in the world, but not this. And don't talk to anyone else about it at this time. I think that's enough. Couple of things. This is a public forum. You're probably going to see people coming in that public door. Sometimes people are interested. It's law enforcement, maybe. Don't panic. They're coming in. They always cruise, security cruises through, make sure we're okay. And they're kind of bored out there when there's nobody there. So they come through. Don't be worried. If there's something wrong, they'll let us know. And so some people may come in, sit down, and then leave. Saying, well, oh, this isn't as exciting as I thought. But so don't let that distract you. And just remember to have the confidence to raise a hand if you can't see, can't hear. You need a break. I'm not going to say, what do you need a break for? I will say, we're taking a break. And that's it. I'm not going to interrogate you. So you don't even have to tell me. All right. So right now, though, I am going to take a break. I'm going to talk to the lawyers here real quickly. And then we're going to come back for openings and then we'll get you on your way. So I put you in Mindy's hands and you'll collect up all their electronic devices if you haven't already. Yeah, that's a good plan too. And we're still on record, right? Good. Okay. All right, why don't we rise with the jurors? First off, I wanted to revisit motions in limine after having an opportunity to more closely review what's charged here. And I did ask the state here, we kind of narrowed it down as we were doing those motions that 9A 9120, 1A sub I sub 2I. So that's what the proceeding is, what you're proceeding under. And so I'm going back to defense motion in limine number 16. Now, kind of broadcast where I am on that. Welcome anybody to say something, but looking at that, when we discuss things, I made a ruling that I thought prior aggressive or violent behavior or prior quote unquote maybe bad acts committed by Mr. Edmondson, actions against Ms. Schulter would be allowed in the sense that they would potentially help form an element of reasonable fear. Well, in looking more closely at 9A 9120 and the law on the WIPICs, since we're only dealing with the first one, which talks about lewd and lascivious, and the second, which is anonymously or repeatedly, and then you look down there, that isn't an element. Reasonable fear. Reasonable fear comes into play if the issue is a threat to the person or a threat to property.
Good.
And so I'm looking at B, oh boy, 1B, with respect to any offense committed under the circumstances identified in A, III, or 4. So therefore, the law does not allow the discussion of prior bad acts to build that reasonable belief or reasonable fear because that isn't an element. So then I'm backtracking on my earlier ruling. I'm granting 16 in that way. There isn't any, I've limited it and it doesn't matter now. So that's where I am.
To clarify,
Yeah.
16 includes allegations of prior assaultive or aggressive behavior. Are you identifying that broadly or defining that broadly to include not just physical behavior, but verbal behavior, behavior online?
So prior bad acts
Well,
outside of this February 4th event. And so, however, if Mr. Edmondson took the stand and opened a door,
I understand.
maybe, we'd have a talk about that outside the jury and see. But the question, I think I kind of pressurized you and I asked, so what are you gonna be asking? And the question of your witness
Right.
here, why did you get the protection order, would not be allowed.
Okay, but I have to address the fact that there's a protection order in order to have a violation of that protection order.
Not necessarily why she got it. Is that? would
But we
bring
can
in-
address it's 4 o'clock and
I understand.
yeah, words are not coming out. Some of the tenets of the protection order refer to him taking down posts that were already up. So I guess,
Well, the
how-
protection order is the protection.
okay,
And
so I mean, I can address what's written on the protection order and
that's my thought. And then,
Yes, Your Honor,
Ms.
I
Barr?
would just like to clarify, the protection order is not an exhibit in evidence. Is
it
that something
will
that
be. Yeah,
the
it
state
is.
should?
I'm
might
sorry,
want to allow-
it is an exhibit in evidence. I'm sorry.
It was not listed in the, I believe, trial memo. That's why I'd like
It's
to
been-
clarify that.
Needs to be marked.
states 3. And why don't you just show Ms. Grove, so you're all on the same page as to,
I have it. I'm just simply saying it was not, and
right.
trying to be an evidence. exhibit in
Okay.
evidence.
So we've got states exhibit 3 in multiple pages. Okay. So no discussion of prior bad acts. And of course, if your client were to take the stand and something opened up the door, we'd discuss that if indeed it did happen or didn't, and whether I would still, then do the exercise and see if there should be anything more. But at this stage, so I'm granting 16 in the fact, no discussion of prior bad acts, no discussion of prior assaultive or aggressive behavior against Ms. Schulte. I gotta get her name right, Schulter. By Mr. Edmondson as because the issue of reasonable fear is not at play here. Any question from defense?
Not on this, Your Honor.
Okay, Ms. Pritikin?
No, no.
Okay. And then the motion to continue on 17285 that's set for next Monday. We kind of tabled that for a moment. Looks like your alleged victim is not available due to a child who has a medical appointment
Correct.
on the 21st, which is the second day, which is when we take evidence. Anything from the defense on that?
No objection to that continuance. I can submit a formal continuance, but I'd be asking to continue the following trial. I'll be at a training, and then on reserve for impeachment witnesses, our investigator Dave will be out until the 30th. So
Okay, so, all right, so the 27th, then you're not available, you're at training.
yeah, I believe so, yes.
Okay, and 28th. So we'll have to kind of rejigger kind of some of all that. Anything from the state on that?
I would just note that the investigator is not listed as a witness, so him being unavailable as a potential impeachment witness is not a reason to continue it. I understand if defense counsel is at a training, that's good cause, but
Yeah.
a rebuttal witness that might or might not be necessary is not.
Well, I find that there's a good cause. You don't have the alleged victim for the 21st. That's good cause. So we'll reset that at some point. We'll have to get these dates nailed down. I do find, attorney training and find it for both sides. That's good cause. We'll get so we'll cancel the 20th, 21st, 27th, and 28th, and we'll reset dates. I don't know if, do you want to put your heads together on that or not, or we'll just try and, sounds like into May is what we're talking at. Very
I
least
have
in the-
2 trials set right now on May 20th, so if we could just avoid the 20th.
Okay. And we're gonna have to give both of you time to let whoever you need to be
Yeah.
here to be here. So it's gonna be at least.
Maybe if we could set a trial confirmation in between.
Yeah, that
We will, don't worry, we will. We'll keep all these together no matter what. And then just a heads up on the jury instructions. We'll get there. We're not talking about them, but you put 12 and it's 6. The very concluding one.
Okay.
Doctors, just know that you're gonna have to fix that.
Okay,
Okay.
We'll
But
fix it tomorrow.
we'll have a far fuller discussion about instructions later. All right, so Minnie and I will figure out dates for those and for both of them, but are we ready then for openings? Pritikin?
Yeah, if we could get a bathroom break just before
Yes,
opening.
you're
I'd
allowed.
appreciate it.
Both, all of you are allowed to take a break. Just make sure that we bumped into jurors. You want to check on them? What?
They're in the room.
Okay, so it looks like you're free to roam, and then
Okay.
why don't we all be back by, quarter after?
Great.
Okay.
Thank
great.
you.
And then we this is marked as
It's exhibit 1.
sorry. Mhm. So, the use of it is allowed and that's expected to be admitted. Fair expectation hasn't been admitted yet, but hearsay, you're
Your Honor, I believe she will be testifying to a certain part of the exhibit, the username, which would be hearsay.
is Pritikin.
The username was is part of the exhibit.
So again, long ago, 15 minutes ago, I gave instructions that said that the lawyer's statements, arguments, statements is where we are, not the evidence nor the law. I will allow, I will overrule the hearsay objection stage and allow the opening to continue.
I'm going to start again. Posted February 3rd, 2025. Regis E. Carly is a piece of shit human. Do not trust this dirty, lying, cum burping, herpes infested, less than human scumbag. She will lie to you, cheat you, steal from you. And if you call her on it, she'll sue you for exposing her ass, lie to Lakewood Municipal Court, and immediately falsely put charges on you out of spite. It's why I got her dumbass on perjury charges. Don't give her your money. She'll fuck you over. Learn from my mistakes, please. That horrible language was part of a review that the defendant, Regis Edmondson, posted online about the victim, Carly Schluter, on a website where you post reviews of service professionals like lawyers, doctors, and accountants. The victim, Carly Schluter, will testify that she previously had a relationship with the defendant over 8 years ago. After the relationship ended, she moved on. She's gotten married, she had a child. She's grown in her professional career, but the defendant posted these vulgar, obscene messages and posts online in 2025. You will see the anti-harassment protection order Ms. Schluter obtained in Pierce County several years ago against the defendant to stop messages, posts, and texts. You will get to see the vulgar messages the defendant posted on experience.com. One on January 21st, 2025, one on February 3rd, 2025, and another on February 4th, 2025. All of these posts were emailed from experience.com to Carly Schluter. All the posts contain language similar to what the defendant used in prior texts and emails, making them easy to identify as coming from him. And he signed his name to all the posts, Regis E, at the top of each and every post. The evidence will show that every single post was in violation of the terms of an anti-harassment order active at that time. The anti-harassment order specifically banned the defendant from cyber harassment and any electronic communication or posts online about Carly. In addition to Carly's testimony about the posts, the website they were posted on, and the anti-harassment order, Thurston County Sheriff's Officer Deputy Carissa Watson will testify to explain the provisions of the anti-harassment order that was in place at this time, who is protected, what she is protected from, and how the defendant, Mr. Edmondson, knew about the order. Deputy Watson will also explain how she obtained screenshots of the post on experience.com from Ms. Schluter. After we have gone through all the testimony, it will become evident beyond a reasonable doubt that these crimes occurred, that Regis Edmondson knew of the existence of the protection order and knowingly posted vulgar messages online about Carly and to Carly, committing the crime of violation of a no contact order. And in posting the vulgar messages on experience.com, the defendant also committed the crime of cyber harassment. Thank you.
Ms. Grove?
Your Honor, permission to move freely about the well.
Sure.
Ladies and gentlemen of the jury, the prosecution cannot just say things. They must prove them beyond a reasonable doubt. Good afternoon. My name is Danielle Grove, as you may remember from jury selection, and I'm proud to represent my client, Mr. Edmondson. Now, the prosecution came up here and said a lot of things, and I disagree with almost all of them. But one thing we can agree on is the vital roles juries play in upholding the Constitution. So I want to thank you for your service on this jury. I know jury duty may seem like a chore. You show up here because of a summons and you're like, oh, great, how can I get out of this? Or maybe you don't. But I believe it is one of the most important roles you can play in this country. And I'm sure in your time serving on this jury, you will realize the duty you have to protect the Constitution. Now I want to introduce you to Mr. Edmondson. Mr. Edmondson grew up in Detroit. He came to Washington to further his career as a chef. He supports his family back home and is in the process of becoming
Objection, appealing to the emotions of the jurors.
Your Honor.
Allow some introduction of the defendant through opening, so overrule the objection.
And he's in the process of becoming a volunteer with Catholic Services, as he was once in need of those services and wants to give back. What happens today will impact Mr. Edmondson.
Objection.
Now, I do sustain the objection, appealing instead of, I do see that it's appeal to the emotional. What I've cautioned is not simply prejudice or personal preference. So move through that to the next issue.
The prosecution shared with you that Deputy Watson responded to a call from Mrs. Schluter about negative reviews posted on the website Experience. The next morning, she received an email from Mrs. Schluter with an attachment of an identical review, a copy paste on the website, and that was posted around 1 a.m. Deputy Watson then contacted Mrs. Schluter to discuss the review. And after that phone call, Deputy Watson concluded her investigation. It's important to understand what the evidence won't show. Deputy Watson never verified the IP address on the post to see if it matched any device owned by Mr. Edmondson. Deputy Watson never collected Mr. Edmondson's phones or computers and other electronic devices. In fact, Deputy Watson never collected any phone, computer, or electronic device during her investigation. Now, the Constitution provides Mr. Edmondson a lot of protections, but there are two cardinal protections I want to discuss. The first is the presumption of innocence. From the moment Mr. Edmondson walked in this courtroom, he is presumed innocent. As he sits there right now, he is presumed innocent. The second protection is the burden of proof, and that falls on the prosecution. Mr. Edmondson is presumed innocent until the prosecution, through credible evidence, proves beyond a reasonable doubt that he did it, and they cannot. As you review the evidence, or the lack of evidence, I trust you will find the only verdict the evidence supports and justice for Mr. Edmondson demands is to find him not guilty, because the prosecution cannot simply say things and have them be true. They must prove it. Thank you.
Sure. So we're gonna, as I said, recess for the day and go back to my recess instruction, which you're gonna hear a lot, and we're gonna give you your phones back and so forth. But so during this recess, and of course every other recess, then you're not to discuss this case with each other. People, facts, issues, places, definitions, nothing. You find something else to talk about. And don't discuss this with anyone else. It includes family, friends, coworkers. So we talked about social media again. Do not go update your social media and say to the world that you're on jury duty. Leave alone. You're not going to say anything. Because then very inadvertently, you're gonna end up being avalanched with information about this trial or maybe other trials, but it's not information that's coming to you in court. And so that would be a violation of your oath and it would cause a mistrial. So don't do that. Don't give, that means don't give information out to anyone. So your family, friends, coworkers who you're, see in person, you gotta say, can't talk about it, tell you all about it later, under court order. Can't talk about it, tell you all about it later. Just remember, you'll be relieved of this order when we're done. So just remember, texts, emails, any way you communicate. You won't communicate about this case to the people or the issues in this case. And let's see, don't allow anyone to give you information about the case. Goes a long way if you don't update on social media and don't talk about it on social media for now. But also if you're out and about and someone approaches you as a part of this case or outside of this case, tries to give you information about people involved, issues involved in this case, anything. Don't then come discuss it with each other. Let Mindy know and we'll figure out what to do from there. And just for now, try to keep yourself free of outside information. So we talked about maybe you're going to avoid all those crime shows, lawyer shows, things like that. Find something else that you find interesting if you're gonna be watching TV. If you're buying a pair of shoes tonight on the internet and you call across something that has to do with this case, you pull yourself away from it immediately and don't look at it. Of course, don't conduct any kind of research into people, places, definitions, anything that we've talked about today. Just leave it alone. You'll have that opportunity later if you really want to when you're done. And we live stream our proceedings here at the district court. Don't go home and watch the Thurston County District Court live stream. It's going to probably be down by the time you get home, but don't go back and look at this proceeding. And then that'll help you keep your mind open and free of outside information that you're not allowed to have. You see, everything comes to you in this court, from the proceedings here. And in that way, you're going to be better able to fairly try this issue and give a fair trial to all sides. So I would ask that you all be back tomorrow morning by 8:45. And Mindy, do you usually look for them or how do you do it?
They're to come in and go straight into the room.
Okay, so they're probably a little lost right now, I'm guessing, but yeah, Mindy will help you figure out where you are. And then you'll come through security and then come directly into the jury room. And so I hope everybody's back by 8:45 so we can get going right away. All right, and water only in the courtroom. I didn't say that before, so you're not in trouble. But coffees or milk or anything, we spill it, it gets to be a mess. So just water. We have lots of water. We have snacks and things in the jury room. And there's coffee and things like that in the jury room. So that's it. Any questions about my orders from my jurors? No? All right. Have a good night. And put you in the hands of Mindy. Gonna stay on record and live streaming it. And let them get in the jury room before we take them to them. Be back at 8:45 tomorrow morning, ready to go. Great, thanks. That's it for tonight.